Your Honor, I'm up first. The clerk had said that you might make some opening remarks before we begin. Oh, Judge McClarty, you're muted.
Okay. Yeah. You are aware you have 15 minutes for your presentation. Did you want to take any time for rebuttal?
Yes, Your Honor. 2 minutes for rebuttal, please.
2 minutes for rebuttal. Okay. And I'll say again, good afternoon to the lawyers. Welcome to the Tennessee Court of Appeals. Your panel consists of Judge Thomas Fryson, Judge Kenneth Armstrong, and myself, Judge John McClarty. The appellant will go first. During the course of this proceeding, if you notice any irregularities or any technical difficulties, please bring that to our attention so we can get that resolved, okay? Do you have any questions from either party?
No, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court, my name is Andrew Pate, and I represent the appellants in this case, Faud Reveiz being the lead style in the case, also Butch Hofferbert and the LLC. Ordinarily, I would say that we are asking this court to reverse the decision below for two reasons, because I've alleged two errors in my brief, but really here it ultimately comes down to one reason, which is that my clients are entitled to their fair day in court. They're entitled to a hearing, and that's what they've been denied repeatedly in this case through essentially manipulations of procedure. And they've never wavered from wanting a trial. There were a number of delays in this case. A lot of those are represented in the record below in terms of counsel substituting multiple times and things of that nature. But ultimately, it came down to a court hearing where they weren't afforded an opportunity to have meaningful representation, to have meaningful preparation, to have a meaningful hearing. And we're asking this court.
Let me ask you a question. Your issue of continuance, was that actually filed in the trial court and ruled upon?
It wasn't actually filed, Your Honor, and there's actually a very specific reason for that, as alleged in the post-trial motion that's in the record, which is that when Mr. Duffy, the trial attorney, or at least the final trial attorney, came on board, he contacted opposing counsel, and again, this is all reflected in the record, that he needed a continuance and was told that wouldn't be agreed, so he was going to have to file a motion for that. When he spoke with the trial clerk, they told him that there were no motion days available before the trial, and so he would need to have an agreement with opposing counsel as to when that motion would be heard off of a normal motion hearing date, which again was withheld. So he asked the trial clerk, the clerk and master's office, point blank, are you saying that essentially under the local rules, my request for continuance is procedurally barred? And was told essentially that that's the case. At the post-trial motion hearing that took place, that's also memorialized in the record, the trial judge acknowledges that and says, essentially, Mr. Duffy, your back was against the wall. You inherited a difficult case, and our local rules essentially prevented you from bailing yourself out. So he didn't file it because he was specifically told by the clerk of master's office, by the trial court, that it was a moot motion, that essentially he was procedurally barred from proceeding with that motion.
So what's in the record regarding this motion to continue then? Is there anything in this record on appeal regarding that motion or that request?
Well, unfortunately, we don't have a trial transcript, Your Honor, so we rely on the statement of evidence that comprises volume 3 of the record, as well as the testimony of trial counsel at the supposed rule 60.02 motion, although it's really requests several forms of relief. And he does make those statements in that motion hearing, and the judge doesn't say that he's incorrect about that. The judge simply ruled that due to the settlement, that they didn't perceive that to be prejudicial, which of course we dispute. But no, there isn't actually a written motion for continuance in the record, again, because of that eccentricity of the local rules that prevented him from being able to actually put any kind of motion on the calendar. He did raise it he says in the post-trial motion that he did raise it in the judge's chambers, but that morning, but we don't have any proof of that in the record because, again, there's no transcript. That was a chambers conversation.
So it's my understanding then this is your only issue that is brought before this court to review at this time?
No, Your Honor.
Okay. Go ahead.
I would say that's a secondary issue. The primary issue that we have is that there shouldn't have been a final judgment entered in this case at all, because the on the day of trial, where although the continuance was barred, it would have been possible to proceed with a trial of some kind that morning. That's what it was set for. The only reason that didn't take place is because a settlement conference took place and was announced to the court. The settlement then was repudiated. The defendants withdrew from the settlement. They filed both a motion that they captioned as a Rule 60.02 motion, as well as an answer that denied all claims and withdrew from the settlement and said that they did not want that settlement to be the order of the court and did not agree to any form of consent decree being entered. And
counsel, as I understand, parties were placed under oath and then asked with regard to the terms of the settlement and whether they consented to the terms of the settlement when it was presented to the trial court. Is that correct?
That's correct, Your Honor. Yes.
What impact does that have with regard to your motion?
None, Your Honor, because simply placing the parties under oath is not dispositive when the court is not on the record. There's no recording or transcript, and all of the cases which present an exception to the usual rule that a settlement that has been withdrawn from cannot be entered as a dissent decree, the lead case on that being Harbor, cited extensively in both sides' briefs, you have to rely on an exception to that. And it is true, Your Honor, that there is an exception when you announce that agreement in open court and place the parties under oath, but it requires several factors to be satisfied. The case that originally established this rule, that had a multi-state survey, was a case called environmental abatement, which I cited. And then there's a Supreme Court of Tennessee case, Ledbetter versus Ledbetter, that sort of canonizes this. And since then, all three sections of the Court of Appeals have followed. And those rules require very explicitly that in order to get into an exception for Harbor and have that consent decree be enforceable and be able to be entered as the order of the court, even though one of the parties has withdrawn consent, it has to have been announced to the trial court on the record. And all of those decisions are very, very clear that it has to be either a court reporter or an audio or video recording or some other kind of exact recording. In the lead case, it says it has to be intended to remain as a perpetual and unimpeachable memorial of the proceedings. And informal notes by the trial judge are not sufficient for that to become enforceable once another party has withdrawn consent to that. If this court were to find, looking at this case on the merits, that a simple announcement under oath in court that is not recorded, is not transcribed, is simply the recollection of the trial judge and of counsel that has no exact record, was sufficient to get into an exception under Harbor, that would be a landmark case. That would be the new rule, and it would go directly against every case that's been decided in this area of jurisprudence across all three sections of the Court of Appeals and in the Tennessee Supreme Court. In fact, environmental abatement has virtually identical facts to this case, and the court below was reversed for entering that order. In that case, there was a sort of mediation, an informal mediation that took place with the trial judge. And so they had a chambers conference, and then the parties discussed a settlement outside chambers. That's exactly what happened in this case. They then went back to the court, were placed under oath, and announced what the terms of their settlement were, but there was no court reporter and no recording device present. And based on recollection of counsel and of the trial court, opposing counsel from the party that later withdrew their consent before an order was entered, drafted an order which the other parties did not approve, which the trial judge then signed and entered, exactly like in this case. And in that case, the court below was reversed. And the key issue for the environmental abatement court was the lack of any sort of exact transcript and the fact that consent had been withdrawn, and that the party seeking relief from the final judgment did not approve, sign, wasn't consulted on the exact language of the consent decree that the trial judge ultimately entered. Again, exactly like in this case, counsel for the plaintiffs drafted what was to be the final order and submitted to the trial judge without running it by Mr. Duffy, who at that time was still a counsel for the defendants, and they signed it and entered it, even though both the answer and the supposed Rule 60.02 motion that had been submitted that repudiated that settlement and withdrew from it had already been stamped on their face by the clerk and master several days, in fact, over a week before this final judgment was entered, and everybody had notice of that. So again, nearly identical to environmental abatement. In fact, even more so because two different repudiations have been formally entered with the clerk. And again, that was considered reversible error in that case. And that's the case that all the other cases, including the Supreme Court case, have followed. So it's our position that, again, the simple statement under oath is nowhere near enough under all the rules that have been put forward by various courts in this case and by other states as well. There's a multi-state survey in several of these cases. You got cases from Iowa and places like that that follow the exact same rule of need and have this exact recording. So ultimately, that's what this case comes down to, is that we get there on the morning of court, and the parties later, all three defendants later state through their counsel that they felt coerced into that settlement that morning and that it wasn't truly voluntary. And it would have been too late for that if it had been announced in front of a court reporter, but it wasn't. And so they simply want their opportunity to be heard and to have a trial on the merits. That's all that they've ever wanted in this case. It's honestly, Your Honor, Your Honors, one of the most modest requests I've ever made to the Court of Appeals is that we're not looking to win here in this court and get everything that we would ask for in the trial court. We simply want an opportunity to present our case on the merits and to have it adjudicated based on findings of fact and law by a trial court. It's also yes, Your Honor.
That's your question. Assuming, and we're only making this for sake of argument, assuming you do prevail in this court, a settlement, isn't that a contractual obligation also?
There is some case law that suggests that a collateral attack under a contract theory might be a remedy that could be available to the other side. But in every case that has considered that, that's been pled by the other side. There's nothing in the record that shows that they pursued that theory at the trial court. And in addition, it's a separate theory from entering a consent decree based on the announcement of a settlement. So what the trial court did in this case would still be reversible error, even if there is ultimately a contractual remedy available and if it falls into the statute of limitations and all the different things that the other side would have to do in order to pursue that theory. If they pled that and filed appropriate pleadings, then that may be something that they could do. There are cases that suggest that, but all those cases are clear. It's a different remedy from simply entering a consent decree based on an announcement of a settlement.
Okay.
And I simply wanted to point out also that the standard of review for the enforceability of these sorts of agreements is de novo without a presumption of correctness. So this court is free to look at the law that I've cited and find that this judgment was not enforceable. It's not an abuse of discretion standard. The continuance is, but the enforceability of a consent decree based on consent of the parties is a de novo without presumption of correctness standard. That comes from Ledbetter versus Ledbetter, the lead case on the same rule that we're citing and relying upon in this case.
Okay.
I did want to also address briefly the fact, see, I only have about a minute and a half left, but there is also a pending motion to dismiss and declare frivolous this case that the court hasn't actually ruled on. And I did file a response to that motion that I think covers my theories on that pretty well. Essentially, that we had a Rule 59.04 motion that did toll our filing deadline. I think that's pretty clear based on the record, but I did want to give the court an opportunity to address that if you had any questions based on that motion or what my basis is for saying that this court does have jurisdiction and that our appeal was timely.
Okay. I hear none.
Okay.
Let me understand your argument about environmental abatement. Are you arguing that the trial judge also mediated the agreement in that case, or was there a different judge that mediated the agreement and then no announcement was made to the trial court and the trial court never approved the settlement in environmental abatement, which makes it different from the case at bar, doesn't it?
That is a slight distinction, Your Honor. It was certainly announced to a judge under oath, as in this case, and that wasn't sufficient. But if you look at Ledbetter versus Ledbetter and several of the other cases that it cites, there are several, and I see that I'm out of time, but there are several other cases that various sections of the Court of Appeals have have heard similar facts. There's a case called State of Cresswell, a case Strickland versus Strickland, across all three sections of the Court of Appeals. And in many of those, they were announced to the trial court, but they all follow the rule that it has to be on the record with either an exact recording or with a court order.
Okay, you have your rebuttal time.
Yes, thank you.
Yes, sir, Mr. Burke. Let's see, Mr. Burke, I think you're muted. Can we?
Can you hear me now, Your Honor?
I can hear you now.
Okay.
Can everybody else hear him all right?
Yes.
Yes.
All right, Mr. Burke.
May it please the court, I'm Ronnie Burke from the Chattanooga Bar, and there are so many both substantive and procedural reasons that the defendant appellant is just wrong in this case that I have filed a motion for frivolous appeal, and I can only remember doing that once previously, and I've been practicing law since 1971. Let me first of all talk about the motion to continue. The judge specifically stated in her orders that there was no written nor any oral motion to continue that was filed. So I don't really understand how they can complain. They're trying to get into conversations with the clerk, various conversations totally outside the record. But the judge specifically stated that there was no motion to continue either in writing or orally. Let me next address the issue of the, first of all, standard of review. I disagree with counsel's statement on that also. If Your Honor will look at the notice of appeal, they are not appealing from the judgment that we got. They are appealing the ruling on September 26, 2019. This is technical record, page 94. They're appealing the ruling on their 60.02 motion, which was on September 26th. In this case, it's important to know the dates. The judgment order from this settlement agreement was entered in the clerk's office after being signed by the judge on August 30th. The notice of appeal was filed 40 days later, not 30 days later, but 40 days later on October 9th, 2019. The only motion that was filed after the judgment order on August 30th was a Rule 60.02 motion. And it is very clear, we've cited on pages 10 and 11 of our brief, the rules that Rule 59.01 contains the types of motions that will extend the time past the 30 days. Rule 60.02 motion is not one of them. The Rule 60.02 motion itself specifically states that it does not extend the time. Trap Rule 4A says you must file the notice of appeal within 30 days of the order you're complaining about, and that you have 30 days after the entry of the judgment. Trap 4B also confirms this. So when counsel says that they're appealed on a Rule 59 motion, that's just not what the record says. The record says they appealed on a Rule 60. And the standard of review on a Rule 60 is totally different. It's an abuse of discretion, and they must present by clear and convincing evidence that the court abused its discretion. They cited no evidence that the judge or chancellor abused her discretion, and the the chancellor specifically stated her reasons for the appeal cited by the defendants and did something that's part of my reason for wanting a frivolous appeal. And the court stated, and I believe I'm going to, if I have time, talk about at least 10 of them, inaccuracies and just plain misstatements by counsel in even filing the motion for new trial, which are part of the appeal here now. The facts. The court said that nothing was heard in chambers except just meeting counsel from Knoxville that she didn't know previously. She said one or both counsel said they wanted to talk. We went out in the hall. After a little over an hour, we came back in and announced that we had a settlement agreement. The facts are that the court heard the details of the settlement agreement. After swearing in the parties, the court heard the details of the settlement agreement. The parties stated that they completely understood the settlement agreement, understood the details of the settlement agreement, and that they were agreeing to this totally voluntarily.
Was this all during the court proceeding? Was this all in court?
That's all in court, and we have made citations to the technical record from the orders of Chancellor Fleener that these things happened. The appellants told the court they wanted to approve it and make it an order of the court. They testified that they were agreeing to this settlement upon advice of counsel, and even counsel asked that it be approved. The court, and this is in Chancellor Fleener's orders, the court made a detailed writing of the record and stated that when the order, which went down on August 30th, that it exactly conformed to the announcement of the settlement under oath in court, and that that was confirmed by her notes. So there was a writing. In the appellant's brief, they say all this was done off the record, and that's just not true. It was done, and if you look at the chancellor's orders, it was all done in open court on the record. It was made under the sworn statements of the defendants with approval of their attorney. Now, the law is, unfortunately, this Harbor case, which was the main case they've relied on, was a case that our office handled and lost. So I'm well aware of that case. In that case, the parties entered into a settlement agreement, and the court wasn't told anything about it. All the court knew is that the parties had reached a settlement agreement. Before the terms were announced to the court, one of the parties changed his mind, and the court entered a general ruling which said that the power of the court to render a judgment by consent is dependent upon the existence of the consent of the parties at the time the agreement receives the sanction of the court or is rendered and promulgated as a judgment. That case was clarified in the REM Enterprises case. It said when the terms of the agreement is announced in open court, that court distinguished the situation from the Harbor case and required the settlement agreement to be enforced. The court said in Harbor, the settlement had not been read in court and had not been made part of the technical record. The terms of the agreement in that case were read in open court to the chancellor, who personally asked each of the parties if they consented to the settlement. Defendant attempted to go through with his purchase of the land. His argument that he withdrew his consent after the conditions and time limit for the agreement had taken place is without merit. Exactly the same thing that happened in our case, because the chancellor personally asked each of the parties if they consented. And in our case, the court even made the parties consent, or didn't make the parties consent, asked about their consent and their voluntary agreement under oath. In the environmental abatement case, it does not state that you have to have a court reporter or an audio or video requirement. It just says that the terms of the settlement should be stated to the court and taken down by the reporter or otherwise reduced to a writing. The court's orders are very explicit that the court did reduce it to a writing and ensured that the order was correct. The Ledbetter case, Ledbetter v. Ledbetter that we cited, again says that that the court should consider whether the agreement received the sanction of the court prior to the repudiation. All of these cases stand for the law that if the agreement receives the sanction of the court, which this one did, the judge asked each of them if they wanted the court to approve the settlement. They all said they did, and the court approved the settlement in open court. They all stand for the status that should be affirmed by the court. If the court rules otherwise, it's going to be hard for anybody to ever settle a case on the day of trial, especially if there is no court reporter. Nobody asserts that the order that the court put down was not the agreement of the parties. That hasn't been asserted. But as I stated, I think that they waited too long to appeal because the Rule 60 motion doesn't stay the running of the 30-day period to appeal. They've also violated Trap Rule 24, which says that the transcript has to be filed within 60 days. They did not file, well, their notice of appeal was filed on October 9th. The transcript was not filed on the 6002 motion until March the 18th, 2020. So, you know, we've got so many things that they've done procedurally and substantively that, and I can't cover them all in 15 minutes. I think I've got them all in my brief. But in addition to all of these problems they've got both substantively and procedurally, what concerns me in this case is that there's also numerous misstatements of fact. If the court will look at the ruling on the Rule 60.02 motion that was filed by the court, I'm going to try to run through as many of the misstatements of fact that were given to Chancellor Fleener. One is it says, contrary to Mr. Duffy's affidavit, that's appellant's trial counsel, that he filed an amended notice of appearance. The record does not reflect the filing of any amended notice of appearance. Two, the court said that the defendant's statement of the evidence attached had handwritten additions that were not in the original motion. I think that was an ethical violation, but you know, the court seemed to be a little upset by that too. Number three, the defense attorney asserted that there was a hearing that took place in the chancellor's office. The chancellor said the only thing that took place in her office was just to meet counsel from Knoxville, and then the parties asked if they could talk. Number four, the court said that the pleading of the appellants was inaccurate in its assertion that the court ordered the parties to talk. The court said it was the parties that asked if they could talk prior to trial. Number five, the chancellor stated that the appellant's statement that they attempted to pursue a continuance of the trial date and sought guidance from the trial court on multiple occasions, but received information that the trial court would not permit pretrial motions of any kind, the court said is also false and inaccurate. The court even expanded on reasons for that. The Chancellor said that contrary to the statement of the defendants, no oral motion was made in chambers and there were no written or oral motions to continue that came before the Chancellor. Number 7, the defendant's statement of evidence also misstated what happened in the trial court, and they attempted to insert exhibits that were not given to the trial court. The court noted that the defendants marked up and changed a version of the Rule 60.02 motion, but not a copy of the actual, that did not comport to the actual motion that was filed. Exhibit number 2 was something that was a copy of a Secretary of State filing that was not ever submitted to the court. Number 8, his affidavit said it only contained matters. Well, I have a total of at least 10 inaccuracies that were given to the court. So we think for all of these reasons, there's no hope for success of this appeal. The appellants have tried to mislead the court, and we believe that the court should not only affirm the judgment, which was not really appealed, but also to declare this to be a frivolous appeal.
Thank you, Mr. Byrd. Yes, sir, you have your rebuttal.
Yes, thank you, Your Honor. To address these arguments, as far as the so-called inaccuracies of the affidavit and the initial Rule 24C filing that was made, as reflected in my response to their motion to have the appeal declared frivolous, these are, some of them are essentially nitpicking the exact way that things were phrased, and others are inapposite or unrelated to the actual merits of this appeal. In addition, Mr. Burke attempts to assert that because frivolous statements were made, or statements he claims to have been frivolous, that somehow that poisons the appeal and makes the appeal frivolous. But in fact, that's not the rule. The rule is whether there are no justiciable issues. And that's simply not the case here. In fact, his motion to dismiss doesn't address either of the certified issues in this case, the continuance or the entry of a consent judgment where consent had been withdrawn. There are justiciable issues. They're the issues that I covered in my case in chief. In addition, speaking about the filing deadline, he makes a great deal of the fact that the title of the motion is a Rule 60.02 motion. We don't dispute that it's called a Rule 60.02 motion in the record. However, the title of the motion is irrelevant. Tennessee Rule of Civil Procedure 8.05 tells us that there's no strict rules as far as what you title your motion. There's even cases where something called a motion to reconsider, which isn't even a motion that we have in Tennessee, was treated as a Rule 59.04 motion because of the contents of the motion. And all the cases on this, Getz, which I cited in my reply, as well as others, say that the court parses through the body of the post-trial motion and determines whether it contains the type of relief sought in a Rule 59.04 motion or other forms of motions that do toll the filing deadline. And of course, because ours does contain that type of relief and did toll the filing deadline, we are allowed to talk about the original order because our deadline was tolled all the way back to the date of the final judgment that we sought relief from. That's the way a Rule 59.04 motion works.
Thank you, sir. Okay.
Thank you.
We will take this case under advisement and you will be notified in due course of time of our opinion on this case. And thank you both for presenting your cases to us. Thank you.
Thank you, Your Honor.
This court is in recess until 2:30 p.m.